Okay, while we are waiting for Kachi to come back, Dr. Adamu, I must say that you're an exceptional person. We deeply appreciate your intervention. We are so very happy to have you on board. We'll proceed very quickly to the next speaker. Professor Adejoke Oyewunmi is a professor of law at the University. She's an intellectual property expert.
Okay.
Here with us. Okay, Kachi, you're back.
Yes, I am back. So here comes the big one from the academia. We have the Unity Bar, has brought us a professor of IP with great regional and international engagements. Just to mention a few, she was for several years a pioneer adjunct lecturer and later professor on the Matters in IP program that was jointly established by the World Intellectual Property Organization, WIPO, the African Regional IP Organization, and the Africa University, Mutare, Zimbabwe in 2008 to develop IP capacity for the continent, that is Africa. She is the author, Nigerian Law of Intellectual Property, and also a co-editor, Intellectual Property in Africa, Principles, Practices, and Management, among other publications. She is currently head, Department of Commercial and Industrial Law, Faculty of Law, University of Lagos. Today, she would share with us on the role of lawyers in clients' commercial obligations, the registry and regulatory organs, and she has the next 15 minutes to do that. Join me as I welcome Professor Adejoke Oyewunmi. Professor, the bar is eager to hear from you, ma'am. Prof, are you here?
Yes, I'm here. Good afternoon, everybody.
Good afternoon, ma'am.
Yes, I thank the Unity Bar. I like that's your designation. Unity Bar and the Trademarks Registry for extending this invitation to me to participate in this very special program on IP due diligence. I have been asked to speak on IP due diligence from the perspective of regulators and regulatory bodies. And I would like to start off by reiterating what earlier speakers have said about the importance of intellectual property. That intellectual property is actually the currency of the modern age, and so it's very important for us to pay due attention to it. Now, my presentation will be structured in this way. First, we're going to introduce the topic and then talk briefly about the importance of IP due diligence in commercial transactions. I'm aware that there's another speaker to focus on due diligence, so I'll just mention it, and then link this with the different types of IPs and their centrality to commercial transactions, especially in the 21st century. This is a century that is characterized by advancement in digital technology. The world has largely moved to the online space, so I'm going to try to forge a link between trademarks and other intellectual property and the digital age. Thereafter, I will look at IP rights generally, trademarks, service marks, copyright, and so forth, and the regulatory agencies, that deal with this right. So we'll be looking at the main regulatory bodies. We'll be looking at the main regulatory bodies, and then we'll also be looking at those whose activities may appear peripheral when it comes to intellectual property, but which, if we're to do proper diligence, we must avert our minds to as lawyers. So,
Professor, ma'am.
Yes.
Hello, ma'am. Please, could you check your end? Yes, please, your sound is not clear enough.
okay?
You have echoes in your background.
Okay. Hello, is this better?
Yes, ma'am. Thank you very much.
All right, okay. Now, so I was saying that we're starting with intellectual property due diligence. And when we talk about intellectual property due diligence, we're talking about activities, legal activities that investigate, identify, and systematically address issues touching on intellectual property assets. And the objective is to confirm the status of the IP rights and also to evaluate actual and potential risks. So you find that as lawyers, when we're dealing directly with IP transactions, you want to register an intellectual property right, or you want to execute an assignment or a license, we think, oh, okay, that's straightforward intellectual property. You know, you go to the registry. My colleagues from the registry have spoken very extensively on what to do, how to go about it. But I want to stretch the boundaries a little and reiterate the importance of the larger picture, that in some other commercial transactions that may on the face of it not really look like IP transactions, but you find that even when you're involved in sale of goods and services, we talk of broadcast rights, you know, television, Nigeria has a very strong entertainment industry. So you're an entertainment lawyer, you're dealing with your clients in that sector, or you want to buy a business, or you are involved in, you know, corporate transactions like mergers and acquisitions, you know, private equity, venture capital, and so on and so forth. Maybe you want to register an SME. Maybe your client is involved in manufacturing and other kinds of commercial or business activities. You may not really think about IP, but you have to, because we are in the information age. This is the information age, and IP due diligence is indispensable because it cuts across different types of commercial and business activities. So if we're to safeguard the interest of our clients, we must be aware and really be alive to our responsibilities, our professional responsibilities as regards due diligence in this area. Now, before I leave the issue of trademarks, okay, it's been treated, but I just want to draw a small link with the online businesses that we have now. We know, of course, that e-commerce, especially in this COVID-19 era, increasingly we've been resorting to dealings online. Businesses that were hitherto mortar and brick businesses with physical offices were shut down for several months. And so people became creative. They went online. More websites were established. And this brings us to the issue of domain names. And so you find that the intersection between the internet, trademarks, and the evolution of domain names creates new dynamics that are being responded to globally through the expansion of the scope of trademark laws to prohibit confusing or misleading domain names derived from trademark rights of others. So in other words, yes, you register your trademark, but you should also avert your mind to the new possibilities, the new realities of life online, and endeavor to safeguard your domain names as well. Now, domain names are the titles with which websites are identified and located. And we find that, you know, trademarks are closely linked to domain names. Why? Because the function of domain names as a business identifiers online means that they help, domain names help to direct users to websites. And so they serve the purpose of providing the public with easy access to information about businesses, while also helping businesses to increase their visibility and promote their profile. And of course, when we start talking about visibility, profile, and all that, we're talking about business reputation, we're talking about goodwill. So you don't want somebody to go and hijack a trademark that you've been using that has become so closely associated with your products or your services, and go and register a website with it and begin to use it to divert attention, because that could have an impact, you know. It's not even could, will definitely have an impact, not only on your goodwill, but also your potential and actual customer base and profitability. And so it's important for us to, you know, be conscious of that. I always like to refer to one of the earliest WIPO arbitration cases, you know, that touched on Nigeria. That's the WIPO arbitration case of Shell International Petroleum and Allen Jones. You know, WIPO has been playing a pivotal role when it comes to the issue of the needed transition from the physical to the online environment. And so we had this case, Shell International Petroleum and Allen Jones. In that case, a young man apparently was the one behind the registration of a domain name. He registered www.shell, you know, Nigeria.com. Now the real Shell is Shell-Nigeria, but he registered Shell Nigeria together, you know, and it was then diverting attention, offering or claiming to have, you know, to offer for sale crude oil and so on. Fortunately, Shell lawyers, you know, were on top of their game, carrying out due diligence. The matter was apprehended. It was duly submitted, you know, for arbitration under the WIPO framework, online dispute resolution framework. And it was found that the man behind the registration was actually a young man by the name, I think, Prof Adejoke or something like that. Just, you know, 20-something, early 20s. He was the one behind it, purporting to be, you know, Shell Nigeria. So you find that businesses can actually lose a lot if they're not diligent when it comes to online activities. Then moving on from there, Nigeria also has a vibrant entertainment industry and is making concerted efforts to improve and promote its performance in other sectors, including manufacturing, agriculture, and other sectors. We know, of course, that all these activities have a bearing on intellectual property rights. So beyond the activities of the Trademarks, Patents, and Designs Registry that are the main bodies, you know, charged with the responsibility of registration, you know, which leads to the initial conferment of the rights. Also, their duties extend to dealings in intellectual property, because we all know intellectual property is a form of property. You can sell it. That is the language of the act, is assignment. So you can sell your IP, you can license it, and so on. But in all these things, it's required that it should be registered. Now your client wants to buy a company. Maybe the company is well known. Unknown to you, it has assigned one of its major IP rights on which you're actually hinging the sale. Maybe that's what has made the sale attractive. Maybe that's why your client wants to pay that much. But you don't know that the trademark has been assigned, or the patents or industrial design rights has been assigned or has been licensed and is the subject of an exclusive license, which means your client cannot, you know, utilize the license. The client now has an empty shell, you know, of a company or a business in his hands if you have not done your due diligence. So it's important to conduct regular searches at the registry to ensure that the interest of your client is safeguarded. Then I'm conscious of the time, but I'll just briefly touch on other bodies whose functions also intersect with intellectual property and call for the exercise of due diligence in IP dealings or in commercial dealings. And these include, for example, the National Office for Technology Acquisition and Protection, that is NOTAP. Hello?
Yes, you can hear you, ma'am.
Yes. The National Office for Technology Acquisition and Protection, that is NOTAP. So we have the NOTAP Act as well as its regulations. And the essence of this framework is the registration of all contracts or agreements for the transfer of foreign technology to Nigerian parties. And this may be in connection with the use of trademarks, patented inventions, and other relevant matters, which means anytime you are involved in a transaction focused on or including trademark licensing, maybe for manufacturing, technical know-how. Sometimes the IP right may not be registered as a patent, it's unregistered trade secret or technical know-how. Even management services, software license, franchises. We know franchises are composite agreements that include licenses, patents perhaps, sometimes industrial designs, sometimes trade secrets, and so on and so forth. When you are involved in all these kind of activities, and those activities involve foreign parties, the NOTAP statute requires that you must register that transaction. And NOTAP also monitors the execution of the contracts or agreements registered with it to ensure that the Nigerian interest is adequately safeguarded. In recent times, they've also upped their game by ensuring that the activities are in line with the government's mission and vision of facilitating ease of doing business in Nigeria. So you have to remember that. More recently, Nigeria also got the Federal Competition and Consumer Protection Commission established under the Act of 2019. Now, that's a very comprehensive and important legislation which provides extensively, for regulatory landscape for businesses, including IP-based businesses, to operate. And at the core of the activities of the Commission is ensuring that there is no abuse of monopoly position, that anti-competitive practices are not permitted, or are not carried out, that public interest consumer protection is safeguarded. Now we know that IP involves exclusive rights. The owner has exclusive rights to deal with the intellectual property. The question then is, how do we, strike the balance? How do we ensure that, yes, while, your client is exercising his right, to exclusive ownership, he also does not run foul of the Federal Competition and Consumer Protection Commission Act. So here you find that it's important to undertake some due diligence to ensure that you don't run foul of the law. Now, if you, very recently, in the last few months, you find that the FCCPA, that's the Competition and Consumer Protection Commission, has opened up investigations into a number of activities. And these activities touch on IP rights, IP ownership, in one way or the other. For example, there was the recent, the most recent, which is possible consumer rights violations in pay TV industry in Nigeria. The investigation was opened up on the 1st of September, just a couple of weeks ago. We know, of course, that IP rights and the television and entertainment industry, work hand in glove. Then we also have product safety concerns following the issue of the blue band spread for bread matter sometime in April. And again, inquiry has been opened on that. Now, if you now have, I think that brand is owned by one of the leading conglomerates in Nigeria. You now have a situation where that is ongoing. You don't know the outcome, you don't know the implications, and your client is involved in a deal, with them. It's important. IP due diligence will help you to ensure that, you safeguard the interest of your clients. Then also recently in May, we had the Med Contour, the unfortunate situation involving loss of lives, I think in the course of cosmetic surgery or something like that. And now the place has been sealed up. You know, that's also at the instance of the FCCPA. Now, how, you know, as lawyers, if you are not aware of this, that, oh, there are ongoing cases or matters, you may not be able to safeguard the interest of your clients. Finally, certain cars were recalled, Ford, you know, the Ford brand, the Lincoln brand, and so on. So you find that, you know, as you talk of brand, as you talk of trademarks and so on, it's not just enough for you to say, oh, you have duly registered. You also must be vigilant. Are there ongoing cases, ongoing situations that require your attention, which you must draw the attention of your clients to? Then let me move quickly to Standards Organization of Nigeria. Their functions also have a bearing on IP due diligence, especially because it touches on investigative and quality assurance roles of that organization. So SON, you know, pursuant to the Act, has a duty to register and regulate standards, marks, and certification under Section 5 of the SON Act. And if you look specifically at Section 5, subsection 1, paragraph K, you find that they have the power to actually register, you know, some sort of standardization marks or certification marks. And of course, the Trademark Registry also has similar powers. So both agencies collaborate to ensure adequate protection of public interest. If you look at Section 25 of the SON Act, Section 25, subsection 5 specifically provides that a standardization mark, that's a certification mark used for the SON certification scheme, shall not be identical with a trademark registered under the Trademarks Act, or so nearly resemble it as to be likely to cause confusion. And the converse is also true. In other words, the Trademarks Act must also avoid a situation where it registers, you know, a mark that is confusingly similar to one registered by SON. So again, we have that. As I wrap up, well, the role of NAFDAC, National Agency for Food and Drug Administration and Control, has been elaborated upon already. I wouldn't want to go in there beyond just saying that, you know, this is a sector that is critical, that touches on the health, the safety and well-being of the public. And so it enjoys a high priority, you know, on the list of things. So you find that in registering, the fact that you have a patent, for example, or that you have a trademark, does not without more give you the right to begin to use that mark to produce certain goods, if the goods are of the kind that need further registration, further, you know, authentication, as it were, under other bodies like NAFDAC. You need to get NAFDAC approval. NAFDAC, for its part, would ask you for your trademark, the trademark you want to use. So again, you have the collaboration. It's important for you to be aware that, you know, you must do your due diligence in safeguarding the interest of your clients. Then we have the trademark practices panel, which whose functions include investigation of trade-related offenses, including those that have to do with labeling, packaging, selling, advertisements, and so on, in a false or misleading manner. You know, of course, when you talk of promotion, advertisements, and so on, these are court trademark functions. So you have this body as well, you know, carrying out some of these duties, you know, of ensuring that the public is not misled or deceived. And so if after the investigation an offense is found to have been committed, then the panel makes a report and action may be instituted as appropriate. We have the National Broadcasting Commission, which is relevant to copyright administration because it plays an important role with regard to the administration of broadcast rights, which is one of the rights granted under the Copyright Act, Section 6, Section 7, I think, right up to Section 9 of the Copyright Act. So the functions of the Broadcasting Commission also, intersect with that of the Copyright Commission. They are not overlapping as such, but again, they collaborate in many respects to ensure that, the operators in that area, owners of radio and TV stations, and so on, are not shortchanged, that rights owners who deal with them are also safeguarded. So you have a client who maybe is in the entertainment industry, maybe is a music producer or a film producer and so on and so forth. You find that the NBC receives, considers and investigates complaints from individuals and bodies regarding the content of a broadcast or conduct of a station. Well, I don't know if I still have time.
All right, Ma, we'll give you another 2 minutes to just wrap up. We have 2 minutes to wrap. Yes, please. Thank you, ma'am.
Yeah, National Film and Video Censors Board is also there, playing a critical role in administration of copyright in the entertainment industry, especially as it affects our vibrant film industry, that's Nollywood. And if you look at Section 2 of the Act establishing the Video and Film Censors Board, it states the important role that it plays in the exploitation of cinematograph works. We know, of course, that cinematograph works are also, fall within the category of works protected under copyright. So you can see the close relationship between both. So the Film and Video Censors Board registers films and video works. It censors those that undermine national security or corrupt private or public morality or are inimical to the promotion of core national values and so on. Now, while the Copyright Commission mandate may not extend this far, it's indisputable that right holders, fall squarely within the scope of the Copyright Act. And so for this category of right holders, you find that, the safeguarding of their interest straddles the Copyright Commission as well as the Film and Video Censors Board and a number of other bodies. I don't have enough time, but I think I'll just stop here for now and conclude by saying that IP due diligence therefore requires that we lawyers must up our game. We must be aware of the environment we are in now. The internet, digital technology, e-commerce, that's one aspect. But even in the brick and mortar world, we find that there are a number of agencies that, we must ensure that we are in touch with, that we interact with when our clients, invite us to be part of some of their dealings or their transactions to ensure that their interests, that they are not shortchanged, that they don't enter into transactions and find that what they have is an empty shell because, under some other law or regulatory body, they cannot meaningfully, exploit or exercise the rights which they think they may have procured, under a particular agreement or contract. I thank you very much.
Well said, Professor. We appreciate you for your time, ma'am. And just like the professor mentioned, all these agencies, I want to use this opportunity to tell all our participants to stay tuned with us. Watch out for our webinar, our flyers on the various internet, your WhatsApp, your groups, your internet handles, and follow us on those other series, because the main mandate of the MBA Unity branch, the Interagency Committee, is to go around like on a tour to various MDAs of government to expose or to learn about their roles vis-a-vis how it affects lawyers-client relationship. So stay with us. Going forward and taking us further into